Hey guys, now that the dust is settling on the anti-SLAPP ruling, let's look at what some of the options are for the parties and some of the complications the litigation chess match introduces. And as the video title suggests, whether this will affect, could you possibly see the FBI letter in the case later? All right, let's go. Of course, first, never write off the possibility this gets worked out. However, if you think that's unlikely at this stage, I certainly agree with you. But it is the eventual fate of most lawsuits, so at some point it might happen. Not every time, of course, but it's the house odds at least. Okay, let's start with Manson since he lost this motion. He can't just drop his lawsuit and file it again, as appealing as that might be. I mean, think about it. The court's not going to just let you do that. Generally, if there's a decision on a claim on the merits, then what's called res judicata prevents refiling. And that's basically just the court saying you can't keep coming here for the same thing over and over again. Once there's a decision made, that's it. That's what appeals are for. And anti-SLAPP motions are considered on the merits. He can't go to trial on the remaining stuff and just appeal later if he doesn't like the result. Anti-SLAPP rulings are appealable immediately. So if a party waits until the case is finished or just simply past the appeal deadline, the appeal is waived. He could drop his lawsuit and pay up the attorney's fees. I don't think so. He can proceed on with what is left of the suit, pay up attorney's fees to defendants and not appeal. Yeah, that doesn't sound good either. Of course, he can appeal, and he said he will appeal. I think that's what he will do, even if his odds are not great. He's got 60 days to do it. At that point, introduces some litigation variables. Because, see, the defendants have not answered the lawsuit yet. They only filed this special motion to strike. It's been pending for over a year, so you'd think they would have had to do other things, but they have not. Usually, you have to answer the lawsuit pretty quickly, admitting or denying the various allegations individually and setting out defenses that you may have to plead. But here's another point. When you file an answer, if you have what we call a counterclaim, in California they call it a cross complaint, that is when you file it, usually. If it's a compulsory counterclaim, in other words, that you must file because it was existing at the time the complaint was filed and it has to do with the same things, you have to do it or you waive it. And that brings us up to the issue of Wood and her allegations of assault. Now that the statute of limitations has changed and allegations of assault after January 1st, 2009 are fair game, she can bring her claim without worrying about the defense of statute of limitations. So is she going to file this? Does she think she has to file it when she answers? While some cross complaints are permissive, I think this one is likely compulsory. Well, her answer and thus the cross complaint will be due before Manson's time for appeal deadline. If I would want Manson to make his appeal if he's going to do it before I file a cross complaint or decide not to. Why let him know what I intend to allege or not allege? Why make the decision before I have to? Now, if I'm Manson, I might wait to file this notice of appeal and see if I can smoke Wood out, force her to answer, and play her move on whether she is going to or not going to file this cross complaint. And then I can decide how to appeal, what to appeal, or not to appeal, depending on what happens. Of course, neither party may think this is a material point, but here's why I do. Let's take the FBI letter, for example. It is struck from the lawsuit complaint as a basis for Manson's claim for monetary damages against Wood. It's out. He cannot use it as an evidentiary weapon against her on offense. However, if she turns around and files a cross lawsuit against Manson, seeking money from Manson, he's entitled to defend himself. You see where I'm going with this? To my mind, any instances where he can, in his view, show that Wood lied about the alleged assaults and the circumstances surrounding it should be relevant and allowed. So the motion to strike and the results of that should not pertain to his use of evidence in defense, because it'd be her seeking money and him only defending himself, which is not a SLAPP situation at all. Opening the door, as it were, which we've all seen parties do to previously excluded evidence. Now, you have a litigation privilege not to be sued on your statements in court proceedings usually, and that's what Wood stood on in the SLAPP motion. But I'm not aware that the statements you make there can't be used to show you're lying when you're the one doing the suing and seeking money. So yeah, if I'm Manson, I want to know if that door's opening. It might affect my appeal strategy a lot. And if I'm Wood, I perhaps don't want Manson to know and want him to have to file his appeal or not knowing. because Wood has to decide if filing a claim is worth opening the door to wide-ranging discovery against her when that door is now mostly closed. Against the benefit, though, of not having to deal with so much deposition and evidence scrutiny right now is the downside that if she does not file, there's the obvious narrative that the state went to all the trouble to change the statute of limitations for victims. You're already in a suit, so why, if you're telling the truth, wouldn't you file this claim against Manson? If she were to waive this claim, it would only make sense for Manson's team to trump at this point over and over and say the only reason would be she doesn't have a real claim. She's lying. So it sure would be nice to know the outcome of the appeal before having to decide if you're Wood, right? For example, if she lost the appeal on, say, the FBI letter and other things, and it's going to be allowed, then keeping the door closed is not even a benefit any longer of not filing a cross complaint. So why not file it after the appeal, especially with this possible potential narrative downside? It's just generally good to force the other side to turn over their cards before you have to. On the flip side, if Wood does file a cross complaint fast with abuse allegations and Manson then appeals the strike order, the case gets frozen for a year. And the last thing people heard was most of Manson's claims getting struck and then Wood going full girl boss mode and countersuing for all the stuff she says he's done. That could be a reason for Manson to appeal quickly, to freeze the case before she has a chance to grab the narrative, because you can't file the cross complaint in the case while it's on appeal because the case is going to be stayed. So maybe Manson waits some of his 60 days to see. And maybe Wood tries to wait him out and go for an extension of time on the answer or some other strategy of holding off until Manson has to move. Of course, maybe they each have their minds made up regardless of what the other side might do, only they know. But while the straightforward scenario is Manson promptly appeals, you can see you need to think on several levels before pulling the trigger on each move. We will see. That's pretty much it for now. Since I don't have a civil case outro, I'm going to use the crime one, and that starts right after I say thanks, bye.